Question number 751. Order 32 of the CPC is related to option A, suit by or against minors and persons of unsound mind, suit by or against trustees, executors and administrators, suit related to the matters concerning family, none of the above. Here correct answer is option A. Order 32 of the CPC is related to suit by or against minors and persons of unsound mind. Question number 752. Under Order 32 Rule 1 of CPC, a minor means a person who has not attained his majority within the meaning of. Here correct answer is option C, that is Indian Majority Act. Question number 753. Whether minor on attaining majority may, if a sole plaintiff apply that a suit instituted in his name by his next friend be dismissed on the ground that it was unreasonable or improper. Correct answer here is option C, that is yes. Question number 754. Proceeding in a suit relating to minor shall not be stayed. Option A, on retirement of the next friend of minor. Option B, on attaining the majority by the minor. Option C, on removal of the next friend of a minor. And option D, on death of the next friend of the minor. Here correct answer is option B, that is on attaining majority by the minor. Proceeding in a suit relating to minor shall not be stayed on attaining majority by the minor. Question number 755. A person who institutes a suit on behalf of minor is known as next friend. Option D here is the right answer. Question number 756. A suit through next friend can be filed by minor, a lunatic, both A and B, none of the above. Correct answer here is option C. Question number 757. A commission to make local investigation can be issued under Order 26 Rule 1, Order 26 Rule 6, Order 26 Rule 9, Order 26 Rule 10 of CPC. Here correct answer is option C, that is Order 26 Rule 9 of CPC. A commission to make local investigation can be issued. Question number 758. A suit may be instituted by a minor in his name by next friend, guardian of minor in his own name, relative of minor in his own name. Correct answer here is option B. A suit may be instituted by a minor in his name by the next friend. Question number 759. A person can act as a next friend if he is major, sound mind, not having any interest adverse to that of minor or lunatic residing in India, fulfilling all the above three requirements. Correct answer is option D, that is fulfilling all the requirement here provided. Question number 760. An agreement or compromise is entered into on behalf of a minor without the leave of the court. Such agreement or compromise under Order 32 Rule 7 of the CPC is valid, void, voidable against all the parties other than the minor, voidable against all the parties including the minor. Correct answer here is option C, voidable against all the parties other than the minor. Question number 761. Under Order 32 Rule 9 of the CPC, a next friend of a minor can be removed if he ceases to reside in India during the pendency of the suit, where his interest becomes adverse to that of the minor, where he does not do his duty for any of the above reasons. Correct answer here is option D, for any of the above reasons. Question number 762. Under Order 32 Rule 10 of CPC, on death of the next friend, the suit shall be dismissed, stayed, rejected, dismissed or rejected. Correct answer here is option B, that is stayed. Question number 763. A person can be appointed as a guardian under Order 32 Rule 4 of CPC on his oral consent, on his written consent, neither A or B, neither A or B. Correct answer here is option B, that is on his consent in writing. Question number 764. Who is guardian ad litem? A person appointed by the court to take legal action on behalf of minor, guardian of the child, stepfather of the child, none of the above. Correct answer is option A. Guardian ad litem is a person who appointed by the court to take legal action on behalf of a minor. Question number 765. The court is required to appoint a guardian ad litem for a minor plaintiff only, for a minor defendant only, for plaintiff and defendant both, none of these. Correct answer here is option B, for minor defendant only. Question number 766. A minor can be legal representative of a deceased person, but in any legal proceeding, such minor must be represented by his next friend or guardian. Here, both these statements and explanations are true is the right answer. Question number 767. Where are the provisions relating to cases of indigent persons given in the CPC? It is provided in under Order 33 of the CPC. So option A here is the right answer. Question number 768. A person is an indigent person within the meaning of Order 33 Rule 1 of CPC if he is not possessed of sufficient means to pay the fee payable on the plaint, any means to pay the fee payable on the plaint, sufficient means for his livelihood, none of the above. Correct answer here is option A. Sufficient means to pay the fee payable on the plaint. Question number 769. In connection with a suit by an indigent person, the suit is deemed to be instituted on the date when the application for the leave to sue as a pauper is made, when such application is admitted, when such application is rejected, none of the above. Correct answer here is option A. In connection with the suit by an indigent person, a suit is deemed to be instituted on the date when the application for leave to sue as pauper is made. Question number 770. Where an indigent person succeeds, the court fee shall be recovered by the state government. Option B here is the right answer. Question number 771. In case the application for permission to sue as pauper is rejected, the suit is deemed to have been instituted under Order 33 Rule 15A of CPC. Options are on the date on which the permission to sue as a pauper refused, on the date on which the court fee is paid, on the date on which the application for permission to sue as pauper is presented, either A, B or C directed by the court. Correct answer here is option C, on the date on which the application for permission to sue as pauper was presented. Question number 772. In which circumstances the court can withdraw permission to sue as an indigent person? If he is guilty of improper conduct in the course of the suit, it appears that his means are such that he ought not to continue the suit as an indigent person. If he entered into an agreement with any other person who has obtained an interest in the subject matter of the suit, all of these. Correct answer here is option D, that is all of these. In all of these circumstances, court can withdraw permission to sue as an indigent person. Question number 773. Under which section or order of the CPC a provision made to provide free legal services to indigent persons? Correct answer here is option C, that is Order 33 Rule 18 of CPC. Question number 774. Rejection of an application for permission to sue as an pauper bars a fresh suit on the same cause of action, does not bar fresh application on the same cause of action if moved along with the amended schedule of property, does not bar a fresh application on the same cause of action with the leave of the court, does not bar a fresh application at all. Correct answer here is option A. Rejection of an application for permission to sue as an pauper bars a fresh application on the same cause of action. Question number 775. What does pauper suit mean? Option A, suit by third party, suit by public servant, suit by indigent person, suit by legal representative. Correct answer here is option C, suit by indigent person. Question number 776. Provisions relating to interpleader suit are contained in Order 26 of CPC, Order 32 of CPC, Order 34 of CPC, Order 35 of CPC. Correct answer here is option D, that is Order 35 of CPC. Question number 777. Which one of the following propositions with regard to an interpleader suit is incorrect? Option A. Defendants claim adversely to one another. B. Plaintiff claims no interest in the subject matter in dispute other than for charges or costs. Real dispute must be between the plaintiff and only one of the defendants. Plaintiff must be ready to deliver the property to the rightful claimant. Here in this question, it has been asked which of the following propositions relating to interpleader suit is incorrect. Here in this question, correct answer is option C. Real dispute must be between the plaintiffs and only one of the defendants is incorrect. Therefore, it will be the right answer, and other propositions are correct. Question number 778. For an interpleader suit, which one of the following condition is not necessary? There must be some debt or some to the property in dispute. Two or more persons claiming the debt or the property in disputes adversely to one another. There must be suit pending wherein the rights of the rival claimants for the debt or the property in dispute can be properly adjudicated. All of the above. Correct answer here is option C. There must be suit pending wherein the rights of the rival claimants for the debt or property in disputes can be properly adjudicated is not necessary. Therefore, it will be the right answer. Question number 779. In an interpleader suit, the plaintiff claims interest in the subject matter of the suit, no interest in the subject matter of the suit except charges or cost, no interest in the subject matter suit, also not claims charges or cost, none of the above. Correct answer here is option B, that is no interest in the subject matter of the suit except charges or cost. Option B is the right answer. Question number 780. In an interpleader suit, plaintiff may claim share in property, right of preemption, cost and charges, ownership. Correct answer here is option C, that is cost or charges. Question number 781. Interpleader suit is a suit between two advocates, between union of government pleader and a state government pleader, instituted by a person who has no interest in the subject matter, instituted by the person who has interest in the subject matter. Here correct answer is option C, instituted by a person who has no interest in the subject matter. Question number 782. A deposits a box of gold coins with B as his agent. He then writes to C for the purpose of making the gold coins a security for a debt due from himself to C. A afterwards alleges that C's debt is satisfied and C alleges the contrary. Both claims the gold coins from B. B may institute an interpleader suit against A, C, none, A and C. Here correct answer is option D, that is A and C. Question number 783. A deposits a box of jewels with B, who is a well-reputed person of his area. C alleges that the jewels were wrongfully obtained from him by A and claims them from B. Legally, B has which of the following options? To return the jewels to A, to deposit the jewels with police, to institute an interpleader suit against A and C? None of these. Here correct answer is option C, that is to institute an interpleader suit against A and C. Question number 784. An interpleader suit cannot be instituted for any property which relates to two persons but which is being held by a third person for the time being, for determining the relation between a property and the persons claiming it, for getting himself absolved from the liability to keep the property which is not being held by him, where a suit is pending in which the rights of all the parties can properly be decided. Correct answer here is option D, where the suit is pending in which the rights of all the parties can properly be decided. Here interpleader suit cannot be instituted. Question number 785. Awarding future interest is mandatory, directory, discretionary, none of the above. Correct answer here is option C, that is discretionary. Question number 786. The provisions regarding friendly suits are in. Here correct answer is option A only, that is section 90 order 36 of the CPC is regarding friendly suits. Question number 787. The provisions regarding summary suits are in. Correct answer is option B, that is order 37 of the CPC. Question number 788. In a summary suit presented under order 37 CPC, it is necessary for the defendant to appear before the court within how many days for the service of the summons of appearance? Here options are 10 days, 15 days, 30 days, 2 months. Correct answer here is option A, that is 10 days. Question number 789. Suit for recovery of money in promissory notes can be filed under normal procedure, under summary procedure as laid down in order 37 CPC in the High Court as a writ petition. Correct answer here is option B, that is under summary procedure as laid down under order 37 of CPC. Question number 790. The period of limitation for filing leave to defend a suit under order 37 of the CPC is within 10 days of the receipt of the summons for judgment, 30 days of the receipt of the summons for judgment, 90 days of the receipt of summons for judgment, 120 days of the receipt for summons of judgment. Here correct answer is option A, that is 10 days of the receipt for summons for judgment. Question number 791. A suit under order 37 of CPC can be filed on the basis of hundi only, bill of exchange only, promissory note only. Here correct answer is option D. D is the right answer. Question number 792. A suit under order 37 of CPC can be based on a hundi, an oral contract, a claim for general damages under section 73 of the Contract Act, none of the above. Correct answer here is option A, a hundi. Question number 793. Which is the correct statement in the context of the summary procedure for civil suits? Option A, may be invoked for recovery of a liquidated demand in a money payable to the defendant arising out a written contract, may be applied suo motu by any civil court in its discretion in the interest of the expeditious adjudication. Option C, requires the defendants to seek to have defend, which if granted must be unconditional. And option D, all these statements are not correct. Here correct answer is option A, may be invoked for recovery of a liquidated demand in money payable to the defendant arising out a written contract. Question number 794. In a suit under order 37 of CPC, the court grants the defendant conditional leave to defend subject to the defendant securing the suit amount by way of bank guarantee. The defendant fails to furnish the bank guarantee in the prescribed period. The court shall permit the defendant to file its written statement, convert the suit into an ordinary suit, decree the same suit against the defendant, decree the plaintiff to elude the evidence. Correct answer here is option C, that is decree the suit against the defendant. Question number 795. The court is entitled to give a summary judgment on a claim in a commercial disputes only in favor of the plaintiff if the defendant has no real prospects of successfully defending the claim, only in favor of the defendant if the plaintiff has no real prospect of succeeding in the claim and there is no other compelling reasons why the claim should not be disposed of before recording oral evidence. Option C, in favor of the plaintiff or defendant as the case may be if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim. Option D, against the plaintiff or defendant if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim as the case may be and there is no other compelling reasons why the claim should not be disposed of before recording of the oral evidence. Here in this question it has been asked, the court is entitled to give summary judgment on a claim in a commercial dispute. Here correct answer is option D. Option D here is the correct answer. Against the plaintiff or defendant if the plaintiff has no real prospect of succeeding on the claim or the defendant has no real prospect of successfully defending the claim as the case may be and there is no other compelling reasons why the claim should not be disposed of or recording of oral evidence. Question number 796. Which of the following suit cannot be disposed of by following summary procedures? Suit for recovery of debt arising on a written contract, suit based upon bill of exchange, suit based upon promissory note and suit for partition of property. Correct answer here is option D, that is suit for partition of property cannot be disposed of by following summary procedure. Other suits for recovery of debt arising on a written contract can be disposed of by summary procedure, and suits based on the bill of exchange also and suit based upon promissory note also can be disposed of by summary process, whereas suit of partition of property cannot be disposed of by following summary procedure. Question number 797. The order 38 of CPC deals with interpleader, summary procedure, arrest and attachment before judgment, temporary injunctions. Correct answer here is option C, that is arrest and attachment before judgment. Question number 798. Under which provision of CPC attachment before judgment is provided? Options are Order 29 Rule 1 and 2, Order 40 Section 96, Order 38 Rule 5 to 13. Here correct answer is option D, that is Order 38 Rule 5 to 13. Question number 799. If the defendant enters on appearance in a suit instituted under Order 37 of the CPC, what shall the plaintiff serve on the defendant in the form of 4A in the Appendix B? Summon for temporary injunction, summons for settlement of issues, summons for judgment, summons for order. Correct answer here is option C, that is summons for judgment. Question number 800. In the Code of Civil Procedure, a civil court can direct attachment before judgment in respect of any property in a proceeding pending before it in accordance with the provisions which are contained in. Correct answer here is Order 38.